Okay, good evening. Let's go ahead and get at it. Thanks for coming to class tonight. Tonight we're going to talk a little bit about environmental law. Now, this admittedly isn't one of the most exciting areas of law, but it's a very important part of American law. This is also an area of law that has evolved quite a bit over the last 50 years. And it's kind of a body of law that makes a lot of headlines today. You think about global warming and the issues related to that. You think about electric cars and tax breaks for buying electric cars and solar panels and things of that nature. Well, all that stuff really has a lot in common with environmental law, where the goal is really to reduce global warming and the damage, so not just the global warming part, the damage that we do to land, air, water, and the rest of our environment. So if you look at your outline, we're going to talk a little bit about the history of environmental law, and frankly, this is actually a very short part of environmental law. There wasn't much for many, many, many years. The reason why we didn't have environmental law is that there was a preference for economic development, driving the economy. Why would you penalize polluters when they're basically hiring people, and those people that are hired buy stuff? That stuff is made by other firms that make that stuff, etc. So you get the idea. But just a little bit of history. You look at your outline, you see two forms of nuisance. Now, for years and years and years, and really centuries, this was all the law that we had. It was nuisance, public nuisance and private nuisance. And what would happen is that one landowner would sue another landowner saying, you're violating my use and enjoyment of my property with your pollution, whatever form of pollution that might be, which could also involve smell and noise and some other things. Okay, but private nuisance, for the most part, was really just private sector owner versus private sector owner. It could be two businesses, two neighbors who are just traditional citizens, or it could be a firm and a traditional citizen, right? And the private nuisance action, frankly, was not very successful. You can imagine juries were just not going to find against a firm who might very well be polluting that is also hiring themselves or their neighbors, etc. So it was there. It's not to say that firms always won these pollution cases, but for the most part, private nuisance just really wasn't that effective at limiting pollution. Now, public nuisance is a little bit different. Public nuisance, of course, involves the government, at least on one of those two sides of things. And if the pollution got to be really, really bad, again, whether it's on land, air, water, wherever, the government might step in and serve as a plaintiff. But even those cases weren't very effective, because even when the government was filing the suit, jurors just weren't going to rule against, if you will, their employer who was employing them, maybe somebody else who, and you kind of get the idea when it comes to the economy. So we're going to really fast forward quite a bit to a discussion on the Environmental Protection Agency. Now, the Environmental Protection Agency was founded in 1970, and it is one of the more salient posts in the administrative cabinet and executive government, largely because it's always been controversial at some level. There are some people on the far right that say we should do away with the EPA. There's some people on the far left that say the EPA should be able to do more. They're not doing enough. Regardless, it's always been a salient kind of group. They've always been in the public interest, one way or the other. Now, interestingly enough, although we generally associate environmental causes with liberal groups, the EPA, of course, was created during the Nixon administration, and the Nixon administration really believed that getting younger persons, or one of the ways to get younger persons on board, at least behind their political camp, was to actually start to protect the environment. So it's interesting that it really does have roots in what would otherwise been a fairly conservative party at the time. Now, the EPA has as its sole mission the ability to write rules to enforce other statutes. Okay, so just like when we were talking about administrative law way back when at the beginning of the course, the EPA is one of those 3 or 4 letter administrative agencies you hear about that have rulemaking authority. Okay, however, the EPA can also engage in investigations. They can also initiate injunctions. Now again, admittedly the injunctions tend to be temporary and the issue is fought out in federal or state court. But nonetheless, they do have the ability to stop certain types of activities. But again, they do write rules that help fine-tune some of the larger statutes that we're going to talk about today. Now, is it possible that the EPA might jump on board in a criminal case? Absolutely. They can work with federal prosecutors to initiate cases whereby the pollution is so bad we would consider it to be a criminal act. Okay. All right. Now, what we're going to do is we're going to break pollution down into several different categories. We're going to look at air, we're going to look at water, we're going to look at land, and then we're going to look at some special statutes that apply here. I think it's just the best way to break it down in a beginning business law course. So let's start with air pollution. Now, air pollution is one of those things that is odorless. You don't see it in most cases, right? So if you walk outside anywhere, there's going to be some pollution and it's going to be invisible. You can't smell it, but it's there. Now, that's not to say it can't be so bad that you don't see it and you don't smell it, but those are the really awful cases, if you will. If you've watched any global news or news around the world whereby you see people wearing masks or something like that, you see this in China and maybe some other Southeast Asian countries, some countries on the African continent where things are so bad that they're willing, people in everyday life are willing to wear protective gear to protect themselves. Those are the bad cases. But in the United States, for the most part, it's odorless. You don't see it, but it's absolutely there, but it's still damaging, all right? It's still absolutely damaging. Now, when we think about what gets out into the air, this could be from a stationary source, such as a factory, or it could be a mobile source, such as a car, right? Or a backhoe, or anything that's essentially mechanized and is burning gasoline or some other type of fossil fuel. Okay, so let's go ahead and start with the Clean Air Act. Now, interestingly enough, the Clean Air Act has its roots in the early 1960s, 1963 to be specific, but it had some amendments in the 1970s, again, including during the Nixon administration, that started to give it some teeth. Now, at first glance, if you look at the Clean Air Act in its beginnings, it was really designed to help states, right? And you're going to see this as a common theme as we go through this section on environmental law, where we just kind of said, okay, states, let's give you some assistance, right, from the federal government, but we also find that that's not enough. Okay, so the amendments in the 1970s really gave the Clean Air Act a lot of teeth. Now, most importantly, the Clean Air Act created the NAAQS system, right? National Ambient Air Quality Standards, all right, for all sorts of pollutants, which basically set a max level, right, across 2 different categories, a primary category and a secondary category. Now, for the primary category, levels to protect humans. At a secondary category, just what you would think, vegetation, animals, climate, visibility, economic values, not related necessarily to human health. All right, so you're thinking of maximum levels of outputs under the NAAQS system, all right? And think of the traditional greenhouse gases, if you will. Carbon monoxide, sulfur oxide, ozone, lead, things of that nature, nitrogen oxide, particulate matter. There are limits on how much of this can be emitted out into the air for both a mobile source as well as a stationary source. Now, the EPA still grants the states the responsibility for enforcement, but provides a lot of backup, if you will, okay? Certainly there's federal funding, all right? There's testing, there's a lot of research, development, things of that nature, all right? But the EPA also writes these rules that tell states what they have to do to meet, perhaps, NAAQS standards in regard to the Clean Air Act. Okay, now each state is required to create a SIP, a state implementation plan, to meet NAAQS, right? The National Ambient Air Quality Standards, right? Now, if you're an Ohioan, and I know many of you are probably too young to remember this, you were alive, but you're probably too young to remember this, but we created the E-Check system in the mid-90s. Largely, this is part of Ohio's SIP plan to meet NAAQS standards, all right? So we said, okay, one of the things we're going to do in Ohio is that we're going to limit pollution from mobile sources, more narrowly cars, right? And that's why you got to get your car e-checked, things of that nature. And the e-check system has changed a little bit over time, but that's what we did. Now, there were alternatives. I mean, one of the things that we could have done was put scrubbers on factory smokestacks, right? You drive by a factory, you see a tall smokestack, and you see pollution coming out of that, and the smokestacks basically, funnel all that pollution up to the point where it's out in the, high sky and not necessarily interfering with those of us on the ground. The thing is, we realize later on it's still bad for you. Okay. But we could have put scrubbers on smokestacks. Now, scrubbers on smokestacks would have been a significant cost to a lot of firms, and maybe to the point where those firms would have said, okay, you know what, we're not doing that, we're going to go move somewhere else. We're not going to stay in Ohio or any other state that might require scrubbers. And scrubbers, I believe, are carbon filters. I'm not overly familiar with the science, but nonetheless, a huge expense, okay? So, states have some flexibility as to how to get there, how to meet the NAAQS requirements, but nonetheless, they do have to kind of engage in a cost-benefit analysis to see what's best for their economies. Okay, now what about areas, right? Might not be the whole state, but areas within the state that don't meet NAAQS standards. These are non-attainment areas, okay? And non-attainment areas are basically measured on a 5-point scale from marginal, moderate, serious, severe to extreme. All right, it's extreme over here and marginal over here. And if this continues to take place, as if a state's area or the state in general can't meet NAAQS requirements, the EPA will step in and take action. And they can do all sorts of things. They can actually overstep the SIP plan and basically say, okay, we're putting a plan into place and you're going to have to follow it. Okay? Now, there are penalties for states that don't engage in SIPs and don't do anything with their non-attainment areas. The two big penalties, number one, you can lose federal highway dollars. Now, that tends to be a fairly common drumbeat when the federal government wants states to do something, and it's not a mandate, but it looks like a mandate, and the state says, oh, well, we're not going to do that, or we can't do that, then they lose federal highway funding. States will generally go out of their way and do whatever it is that they have to make sure that they get those federal highway dollars. The second, and depending upon who you talk to, might be the more draconian enforcement mechanism or penalty, is the fact that a state might be told you cannot have any new sources of pollution emissions. Now, to a state, that might mean no new factories, no new businesses, no new job creation, things of that nature. So there's a real emphasis on states making sure that their SIP plans work, and that these non-attainment areas where they do pop up, are all the way from marginal to extreme, that they're taken care of pretty quickly. Okay, now the Clean Air Act does specifically address toxic air pollutants. And a toxic air pollutant is something that is likely to cause death or serious injury, serious chronic problems that go on and on and on without a whole lot of hope in the long term, in the sense that this is part of your everyday life if you're suffering from something that's chronic. All right, there are over 200 chemicals or substances that are listed under the Clean Air Act as toxic pollutants, and some of the ones you'd probably just imagine. Right, one is asbestos, mercury, beryllium, benzene, some of the worst things. Right, and essentially there is almost a zero tolerance policy in terms of exposure. So the average everyday person cannot be exposed to these. Now, you might say, well, wait a minute, what if the technology isn't quite up to snuff whereby we can protect people from this? Well, then you simply can't use one of those chemicals, right? At least you can't use that chemical in that particular area. So this is kind of a good example when it comes to toxic air pollutants, whereby we ask technology to catch up with the law. It doesn't happen too often, but that's just a good example there. Okay, let's look at water pollution. So we've looked at air, now let's look at water. And water affects everything. It affects humans, animals, plants, vegetation in any way. Think about our agriculture and how dependent upon we are for that. And again, it could be the animals that are part of agriculture and the plants that are part of agriculture. Having clean water, a clean water supply is very, very important. Now, this is an area of environmental law that really just wasn't touched for a long period of time. But if you look at your outline, all right, you see the River and Harbor Act of 1886, and it really didn't do a whole lot to protect the waterways. I mean, it just didn't. But the first thing that it did, and something that you're going to see as a common thread throughout the rest of this body of law, environmental law, is it created a permit system. All right. So for the first time, if you wanted to emit whatever, now we're not talking about air now, we're talking about water, but if you wanted to emit water pollution, let's say something that would, some substance that would pollute water, you had to have a permit to do so, right? So for the very first time, we're saying, hey, check with the government, and you have to have a permit. Now, as you can imagine, in 1886 and for a long period of time, really through the 1970s, the government never said no. They just said, let us know that you're doing it. And that was really kind of all the permit system did. But the permit system was pretty broad. It dealt with both sewage and refuse issues. It didn't really do a good job of defining waste, but again, it was certainly a start, okay? Now, fast forward nearly 100 years, and Congress created the National Pollutant Discharge Elimination System. And what this did is it really started to put government in the position where it could say no, right? You got a permit, all right, but maybe we're only going to say so much. Or maybe depending upon what it is you're thinking about doing, we're just going to flat out say no, okay? So broaden the spectrum of permits. You could be denied a permit, or you could have a permit that was limiting. And again, there are different kinds, I mean, literally hundreds of permits. We're not going to go through all of that. Okay, but the Clean Water Act, all right, much like the Clean Air Act, did have a predecessor before the 1970s. 1948, the statute is passed. All right. And it did have a permit system. It did, much like the Clean Air Act of 1963, said states, you need to do all the enforcement, we'll write the rules. All right. But it really started to get teeth in 1972 and 1977 with some later amendments, and then also the Water Quality Act of 1987, which gave it even some more oomph. Okay? Now, when it comes to water pollution, there are standards for what it is you can put into our waterways. Again, anything that's potable, that's drinking water, anything that's designed for drinking, but also in navigable waterways. Could be drinking on one hand, as I've just said, but also water that's used in agriculture, swimming, fishing, industrial use, etc. Okay, now when it comes to point sources of water pollution, this is a very important term, right? So circle, underline, asterisk, highlight, point source, all right? You have to have a permit that addresses the point source. And the point source is essentially the point where it's going into the waterway. So think of a long tube, all right, a long pipe, if you will, and that's the point source whereby the water, or the pollution is going into the water, all right? And it can come from mines, manufacturing plants, cities, electric plants, paper mills, oil wells, you name it. Think of fracking here in Ohio and western Pennsylvania and western New York. You got to have a permit that addresses that point source more specifically. Okay, now the Clean Water Act also requires a lot of record keeping. So one, you got to get a permit. It's got to be based on or associated with that point source, but also you have to keep records of what you're putting in the waterway and how much you're putting in the waterway. All right. You also have to upgrade your equipment routinely. All right. So if there's equipment, it's generally the standard is best available technology. So it's not a zero tolerance system, but you have to generally have some pretty good stuff. And when there's a new wave of protective equipment, then you have to adopt that as well. You also have to keep samples of what it is that you're putting into the water, again, from that point source, right? Wherever that point source is and whatever that permit addresses. Okay, now, one of the issues that went unaddressed for a long, long period of time, really until about the 1990s, was thermal pollution. Now, here you're looking at water that might not necessarily have something dangerous in it. It might not have a foreign substance in it, but it was hot. It was overly hot water. So think about firms that use a lot of machinery, a machinery that runs hot, and you need to intake, say, from a local lake or river. The water goes in, cools the machines, and then of course once it's cooled the machine, right, it goes out back into the lake or river or what have you. Now, why is that a problem? Well, it's largely a problem because when you put hot water in an existing water source, right, river, lake, pond, whatever, right, heats the water, reduces the amount of oxygen, all right, making it very, very difficult for fish to live, plants, etc. So, with that said, thermal pollution, if identified, simply can be banned. Again, from the point source, thermal pollution, in other words, is not treated any differently than any other type of substance you might put into water. Okay, now, just a quick note on wetlands. Now, wetlands, you probably know what they are because you've driven by them. It's your swamp, your bog, what have you. You drive by and you see cattails sticking out in water, and it almost always floods and that type of thing. But why wetlands are so important is they tend to protect very specific habitat. Obviously, we don't have many left. During the last half of the 19th century and all the way through the 20th, we were draining these routinely, and there wasn't a whole lot of protection, all right? Marshes, bogs, swamps, etc. Okay, now, in order to dredge or drain a wetland for some form of economic development. So again, think of a new shopping mall, highway, office building, what have you. If there's a wetlands, marsh, bog, swamp, whatever, in the way, so to speak, you do have to have a permit to drain it and dredge it. Now, often you will see that the federal government will say no. More specifically, the permit comes from the Army Corps of Engineers, and they can say no. Say, look, you're going to have to put this shopping mall or this highway or this office building somewhere else, just not here. All right, now, there are situations whereby the federal government will step in and say, okay, look, we know that we need a highway, a shopping mall, or an office building in this particular way. We want economic development. We want firms to be able to develop the property that they own. That's seen as kind of a right of property owners. But there's a wetland, marsh, swamp, bog right here. What can we do? Well, maybe in order to get the permit to dredge it and drain it, you also have to reconstruct a wetland somewhere else, and probably very close by, right? And over the last 30 years, you've seen a lot of this. So it's almost kind of been a form of reclamation in the sense that you're not restoring the traditional property where the wetland was, but you're maybe moving it, and you can build a wetland. And you try to make it as natural as possible, making sure that whatever kind of vegetation and animal life that the now dredged or drained wetland at one time protected can be protected in the new one. Okay, now if you look at your outline, you see the Safe Drinking Water Act of 1974, probably one of the most important statutes, certainly helped with suburbia. Many of you may have well water instead of, say, city water or village water that's piped in, but you have to drill down, find access to an aquifer, and of course you get water that way. But think of how dangerous it was at one time when there was really not a whole lot of law protecting drinking water. But this particular statute basically prohibits anything that would be considered dangerous to human health from being dumped into a water well, all right? A water well that would be used for potable water. Okay, look at ocean dumping. Now again, there are two statutes that we're going to address here. You know, over the last 30 years, there have been some very noteworthy accidents. Think about the Exxon Valdez in 1989. Think about the Gulf oil leak that we had. And again, not necessarily attached to or associated with a ship, but certainly think about the oil spills that we've seen in the Gulf in 2010, a very, very serious one for that matter. Okay, the Marine Protection Research and Sanctuaries Act of 1972 really kind of does just what you would think, right? Requires a permit for any type of dumping of waste, any kind of waste, doesn't have to be hazardous, any kind of waste into the oceans. And frankly, it's very difficult to get those types of permits. So again, this is something you should see. And again, this is the 1972 statute. A lot of amendments, by the way, to the laws we had looked at so far. There was a 72 amendment to the Clean Air Act, 72 amendment to the Clean Water Act. Tie this to the creation of the Environmental Protection Agency of 1970. Starting to see how the early 70s were a big part of environmental law birth, if you will. Okay, but nonetheless, a permit system was put in place under this 1972 statute, but also you saw a lot of grounds for denial. It is very difficult to get a permit to dump waste into the ocean. Now, the second thing that it did, if you look at that little that word there towards the end of the name of the statute, sanctuaries, it created sanctuaries where you literally can't do anything, all right, with that particular area. This is considered an area that's so unique that needs special protection because of maybe the unique aqua life that you see there, or underwater plant life needing, again, more than average protection. That statute does handle it. Now, the Marine Protection Research and Sanctuaries Act also does address oil spills. Basically, it gives the federal government the ability to clean up anything within 12 miles of shore, assess the cleanup costs to whomever did it. Now, this is very much akin to what we're going to see here in a little bit with CERCLA, which is more of a land pollution law, but nonetheless, giving the federal government the ability to say, hey, we're not waiting around to assess blame, we'll clean it up first, and then we'll assess blame later. Now, the Oil Pollution Act of 1990 really had a specific mission, and that was to make sure that oil spills like that associated with the Exxon Valdez in 1989 wouldn't happen again. I was in college at the time, and I can just remember it just went on and on and on how awful this oil spill was. And again, it permanently damaged a particular body of water, but also think about the economy, destroying a beach, destroying the living of a lot of people that were engaged in the fishing industry at that time. I mean, everything just kind of died. It was awful. So, nonetheless, what it did more narrowly, this 1990 statute, is it created a new set of procedures for dealing with oil spills, right? We won't get into all those procedures, okay? But two very important provisions. Number one, although they're both related, number one, it required that all new oil tankers built since that point in time, since 1990, must be built with two hulls, right? So you started to see the creation of double-hulled, H-U-L-L-E-D, ships, right? And these double-hulled ships, the promise, of course, would be that, you know, if you hit something and you ruptured the first hull, there's a second hull in there keeping the oil within the ship. All right, second, very much related, that older ships, all right, would be phased out over time. All right, so we're at the point now in 2017 where there should not be any ships, right, within American waters that are not double-hulled. Okay, regular ships all had to be phased out by 2010, so you had roughly a 20-year run where some of the older ships were grandfathered, and the message was, hey, if you've got these older ships, then you need to start cycling them out and plan accordingly in terms of finance and capital and getting those things out. And barges had to be all phased out by 2015, so now we're 2 years past that. So really, whether it's a barge, oil tanker, traditional oil tanker ship, any kind of oil ship, they all should be built with double hulls if they're operating in American waters. Now that includes, of course, ships that might be chartered in some other country. If they're coming into American ports, they do have to be double hulled. Okay, now let's look at land pollution, and we're not going to take the exact approach that we did with air pollution and water pollution. We're going to break this up just a little bit more and start with toxic substances. Now, we had a little bit of discussion in terms of what was toxic and being putting into the air and the NAAQS system, okay? But this is dumping it on Mother Earth, right? So think about the pesticides, fungicides, rodenticides that we use to protect crops and agricultural runoff, things of that nature, things that are going to cause cancer, birth defects, and not just humans, but also certainly animals that will kill other forms of vegetation and wildlife. Okay, so what we're going to do is we're going to look at FIFRA, okay? Now, all these statutes have these very long acronyms, so this is one of our first ones here. But this is the Federal Insecticide, Fungicide, and Rodenticide Act, all right, FIFRA. Okay, now it also had a 1940s, much like the Clean Air Act predecessor, but it did not get teeth really until the 1970s, as you can imagine, 1972. Now, in 1970, of course, the Environmental Protection Agency was crafted, and in 1972, by statute, the EPA was allowed to create rules on these three types of substances, things that would kill insects, things that would kill fungi, again, things that might grow on crops and might limit your harvest, your yield, what have you. And then, of course, also rodents, all right? Now, any substance not only has to, can only be used with a permit, everything has to be registered, all right? And the EPA can also limit or bar its use. So one, you got to get a permit, you got to register. Two, and three, the EPA can certainly say no, right, if they find problems. And again, the EPA does a lot of its own research and, of course, farms out research to universities like the University of Akron. And when we find things out that might affect EPA policy, etc. Okay. Now, the Toxic Substances Control Act of 1976 went a little bit further. And so, although FIFRA deals with agriculture for the most part, now again, anything to kill insects, fungi, and rodents, just most of it deals with the agriculture sector. The Toxic Substances Control Act of 1976 more narrowly deals with chemicals used in the manufacturing process. Again, you can't use it unless the EPA says okay. You need a permit, so it's got to be registered. You need a permit. They can say no, and they can say, well, here are going to be some limits, all right? Now, with both FIFRA as well as the Toxic Substances Control Act of 1976, there are some very rigid, I would say, requirements on express labeling, all right, letting the user know what the risks might be if this product is used in certain quantities, okay? Now, if as you can imagine, generally the people that might be handling these types of substances are going to be some of your very well-trained professionals, and they're going to know this stuff, but nonetheless, when you think about the express warnings or express labels or instructions, you know, even to those well-trained professionals, that stuff's going to become very, very important. Okay, let's look at hazardous waste. Now, I would argue that these next two statutes are probably the most controversial, at least in regard to pure economic development, and certainly at the time, not only not only controversial, but maybe the two statutes whereby as soon as they were birthed, they had some very significant teeth, some backup. So, you know, we've looked at some other statutes that had like a 1940s or early 1960s predecessors, and they didn't get teeth till the 1970s. These statutes had teeth almost right away. So the first one is RCRA, all right, the Resource Conservation and Recovery Act of 1976. Now what it does is it creates a cradle-to-grave system for all hazardous substances. So not only how they're created, but also how they're disposed of. So everything in the middle. How they're generated, how they're treated, stored, transported, really everything in between. Again, cradle to grave. And it also prohibits many substances that we've learned that over time, they're just not something that we should be using. Okay, now let's define a hazardous waste. Now a lot of times we think of hazardous waste as something that's solid. It doesn't have to be solid, certainly could be liquid. It can be gas as well. Certainly be the smaller of those three buckets. But a solid waste that may cause or significantly contribute to an increase in mortality or serious illness. Okay, so two key things. Might kill you. It might seriously make you ill. Okay, those are the big standards. But again, it could be something that's toxic, corrosive, radioactive, something that's going to catch fire. All of those things. Okay. Now, once again, you need a permit, but it's a permit for everything, the whole cradle-to-grave system. So generating it, storing it, transporting it. After it's used, how to collect it, all right, everything. Okay, now, CERCLA, all right, just 4 years later, so not quite the 1970s, but almost right out of the 1970s. This is known as the Superfund statute, all right, but its full name, the Comprehensive Environmental Response, Compensation, and Liability Act of 1980. Now, of all of those words, the most important word in that statute is liability. It created a massive liability system for those who were responsible for polluting land, all right? Largely through the dumping of those hazardous wastes that we've just defined. Again, something that's going to kill you or make you seriously ill. Okay, and again, the nickname for this statute is Superfund, and essentially the reason why it's called Superfund is that it created just what it sounds like, a super fund, a big pile of money, largely through taxes on some of these hazardous substances and chemicals that could be used. Again, you could still use them, you had to buy them, you pay the tax, and those taxes went into a big pool of money that the federal government would use to clean some of these Superfund sites out, okay? Now, CERCLA created a system whereby the federal government would identify what we would call today a brownfield, right? So not a green field, but a brownfield, something that's already been developed, that's been used maybe for decades and decades and decades. As an example, cities in the Rust Belt, Cleveland, Akron, Canton, Youngstown, Warren, Lorain, we have lots of these. Massillon, we have lots of these. Okay, but they would identify the site, right, and then rank them, right? So you're looking at roughly 300,000 Superfund sites, and they are ranked in terms of most dangerous, most toxic at the top, to the ones not so much. All bad, of course, right? And they would be cleaned up, right, starting with the top, okay? Now, and again, these substances could be anything. It could be oil, motor fuels, could be all the rodenticide, fungicide, insecticide stuff just dumped. And we did this for decades. We just dumped stuff on the ground. I didn't think twice about it, even though we later found out, of course, how damaging it was to human health, and we investigated it and we found out essentially what took place. Okay, now the liability provisions, getting to the liability, very significant, all right? If you own it, you're liable. If you dumped on it, you're liable, all right? If you transported stuff there and dumped it there, even though it wasn't your property, you're liable, all right? So this massive liability structure, okay? Now, much like with some statutes that we looked at earlier, the federal government can sue right away, or can clean it up and then go after the polluters that way, right? Now, generally, when it comes to Superfund sites, you see a lot of the latter, right? Especially starting from the 1980s. Identify the site, get it cleaned up, and then go after the polluters. And this is kind of what it made it somewhat controversial. A lot of those polluters were saying, now, wait a minute, I didn't know this at the time. And when this goes back decades, by the way. I mean, people that were polluting in the 20s and 30s, 40s could be liable here in, starting in 1980 and through the year 2017. I don't expect it certainly to go away. Okay, but again, if you generated it and took it there, you owned it at one time, you owned it when it was dumped there, you own it now, they all could be liable. So what the federal government does is basically goes after all of them, right? Or one of them. They're jointly and severally liable, as you see from your outline. Can go after all of them or one of them, and then once the federal government has its money back, essentially from cleaning up the Superfund site, then those parties, the generators who drove it there and dumped it there, the previous owners, the current, they can go sue each other, right? Federal government doesn't care, says, hey, you guys go sue each other a little bit later and decide who's really responsible then. But you can imagine how important when it comes to one of these CERCLA actions, Superfund actions, record keeping is. I mean, if you have records as to what was dumped, when it was dumped, who owned it when it was dumped, right? It's a nice evidence trail to find out exactly who's responsible for dumping this stuff. Okay, now Superfund, CERCLA, if you will, also has some notice requirements, right? So if you are a current owner, you do have a responsibility to find out, right, reasonably find out what's there, right, what's on Mother Earth, right, your property, and then two, warn people. And certainly if you're thinking about selling that property, warning people, so it's just kind of like you're selling your house. You have a disclosure statement. This is no different, but of course we're talking about maybe millions of dollars, and in some cases probably billions when you get to the larger cases. Okay, you have to immediately notify the government under CERCLA if there is a news spill, all right? So it's one thing telling people, becoming aware of what's been on the property before, but you also have to let the federal government know if there's a news spill, okay? So again, very comprehensive statute. Okay, now let's talk about endangered species. Now, you might not think of endangered species as necessarily something that's polluting the land. However, it's land pollution or environmental damage due to economic development that creates this kind of problem. Okay, now when it comes to the Endangered Species Act of 1973, so just the year after all those 1972 statutes were passed through, it identified three different levels of animals, right? So essentially those that are threatened, right, get some protection. Endangered get much more protection, and even those that are extinct. Now you might say, well, Tudor, how in the world can you protect extinct animals? Well, essentially they're put on the list and you hope you find one. All right, so nonetheless, that animal is going to get some protection, even if we can't find one right now. The possibility of it coming back in terms of its value to biological diversity is very, very important. Okay, so it is the Secretary of the Interior that's responsible for enforcing this particular statute, and they will identify any animals that fall into one of those three categories and into which category. Okay, animals can move from category to category. They can be threatened at first and then become endangered, where they get additional protection. Unfortunately, they can become, they could move from endangered to extinct. All right, but as they're given protection, can they go from extinct to endangered, perhaps to threatened? Absolutely possible. Okay, now, where you see the most litigation when it comes to this particular statute is the permit system. Okay, so again, a constant drumbeat throughout environmental law, but the concern becomes, well, I want to engage in real estate development or some other form of economic development, and there happens to be wildlife that's either threatened, endangered, or extinct. Can I still build there? The answer is possibly, but it's going to be very, very difficult to do so. Okay, so if you do have a permit, there are going to be some substantial limitations on what you can do. Now, in terms of interfering with that particular animal, if you will, that particular species, there's a pretty broad stroke approach, right? So if you look at the particular statute, you're going to see that the statute creates a critical habitat, so kind of defining, if you will, what makes the habitat unique and special to that particular animal that it needs to thrive or exist, all right? And then also prohibits anything interfering with that particular animal. So it's not just the definition of the critical habitat, but also the interfering with that animal's life. Now, if you look at the particular statute here, the Endangered Species Act, the term used is taking, right? And what I want to do is just kind of read through some terms that in the statute are associated with taking of a species. All right, it's a pretty long list. Harasses, harms, hunts, shoots, wounds, kills, traps, captures any endangered, threatened, or extinct species. So that's quite a bit. You can't do any of those things, right? You can't do any of those things. So you can't. They crafted a term that was so broad, and then of course did a good job of defining what that term "taking" meant, to the point where, you know, you can't. If you're a property developer, you can't say, "Well, I'm not killing it," or "I'm not wounding it." It's like, well, are you harassing it? Are you, harming it? Those are pretty broad stroke terms. Hidden with even a broader stroke term, if you will. So nonetheless, a pretty ironclad law. It's not to say that it's not violated routinely. Again, hunting is still a problem, even separate from economic development. It's just economic developers, believe it or not, have a fairly good record of making sure that they get their permits. They adhere to the permits. It's hunting that's probably the bigger problem, I should say. Okay, let's talk about something that I've always found interesting, and that's noise pollution. Nobody likes it, and so I'm not interested in the sense that I enjoy it. But it is something we often don't think about. I mean, if you live in a small town, you don't have a lot of it. I mean, it's just reality. You go to a bigger city, and I mean, if you just kind of notice that it's there, and imagine that, this noise is continuing to the point where you can't live a nice, quiet, enjoyable life. Now, some people might say, hey, if you don't like the noise, you got to get out of here, okay? And we're not going to get into at what decibel level, you're violating a particular statute designed to curb noise pollution, but there are a couple statutes that I want to go through that are fairly important. And again, as you see from your outline, both the 1970s. So the 1970s, again, you really saw this birth and growth of environmental law, which is really, really quite interesting. Okay, let's look at noise pollution first. Now, noise pollution comes from lots of sources. You think of heavy machines or factories or cars or things like that, but it could be toys, lawn equipment, things of that nature, okay? Now, the Noise Control Act of 1972, all right, creates maximum noise levels for certain products, certain goods, okay? Now, notice, all right, this is a little bit different than what we covered in regard to consumer protection law. All right, it's the EPA that sets these standards, not the Consumer Product Safety Commission that you might otherwise think. Now, they make sure it's safe, but they don't address at all noise emitting from that. Okay, now you might think of cars and manufacturing plants or machines at the manufacturing plant. Those would probably be your bigger problems. Heavy construction equipment, things like that, but even toys. Right? So even think about how noisy Christmas or Hanukkah or birthdays might be otherwise. Okay. All right. Now, believe it or not, this particular statute does address aircraft. All right, does set standards for aircraft, and again, for those aerospace engineers out there, there is a responsibility to make sure the plane is not too loud. Now, obviously, it can be loud, but just can't be too loud. And again, we're not going to get into what too loud is on a decibel level. Okay, and then the 1978 statute was the Quiet Communities Act of 1978. it was probably one of the more helpful statutes in the sense that it gave money in the form of block grants to local governments, not state governments, by the way, directly to local governments to help find ways to reduce noise pollution, okay? Railroad tracks, things like that. I think that's always a good thing when you see a law that says, hey, you know what, maybe craft your own solution that helps reduce noise. Okay. Now, one thing that we're not going to address a traditional environmental statute to, in the sense that we don't have one that really helps here, is indoor pollution. Okay. Now, in buildings like the one I'm in today here at Wayne College in Orrville, the air in this place is probably a lot worse than the air out there. Okay, you probably can't hear it, but I can hear the air ducts blowing air in, but you kind of wonder where that air is coming from, and most of it, frankly, is just getting recirculated around. So when it comes to indoor pollution, think of all the things that could create greater pollution. You know, here at Wayne College, it could be and I assure you this place is, you know, it's nice and safe, but because we have the necessary equipment, but biology labs, right? Think about copiers constantly emitting, all right, something, all right? But again, think of the health-related issues that are created just through indoor air. When, you know, if I walk right outside here, the air is probably a lot better, okay? Now, what I can tell you, again, as I'd mentioned, there is no federal environmental statute that applies to this, okay? That's traditional environmental law. What we do have, of course, is the Occupational Safety and Health Act, right, which created its own administrative agency, one of those 3 or 4 letters, this just has to be 4-letter administrative agency, OSHA, which does govern workplace danger, all right? If the air is so bad in your workplace, right, well, that place could be so unhealthy that it was shut down. Okay, and again, you get into the same things we talked about when we were looking at employment law, in the sense you can't force people to work in a dangerous environment, even if it is just the air. I mean, the air in this place is probably, and this is true of all buildings and probably skyscrapers, even more so for those of you that might work in there, but cleaning agents, copy machines, all that stuff puts a lot of stuff in the air, and then of course it's just recirculated. Okay, so again, no traditional environmental law statute applies here, but OSHA does.